Okay, just a quick intro. So today we're going to be talking about estate planning and thinking about this not only through what we're going on in COVID-19, but depressed asset prices and low interest rates. A little background on Laura. I've known Laura for quite a long time, and she has her own law firm today, a trust and estates planning law firm. And she specializes in advising high net worth clients in their life and also in postmortem strategies to reduce gift, estate, generation skipping, transfer taxes on transfers of properties, as well as trust and estates administration. Laura graduated from University of Pennsylvania and then went on to law school at NYU here, literally next outside of my window right now. And then she went to work at Wilkie and now has her own firm. Laura, fun fact, Laura is also the most fun trust and estates attorney I've ever met in my entire life.
Thank you. That's not saying a lot, but thank you.
Okay, to go on. So, Laura, to turn it over to talk about estate planning during these times, focusing on, the fact that it's very scary. Death is in front of us today, especially here in New York City. We're seeing it, every single day, and people that we know and love. As well as the fact that we can't go outside, we can't go to our state attorney's office, we can't think about these things. So I want to start off kind of with a level playing field. So what are the basic documents we should all make sure that we have, not only right now, but just always in thinking about this?
So you're right. We're living in a time where we have to face our mortality. Typically, when people are doing planning, there's no imminent threat. And it happens to be that right now there is an imminent threat that's very difficult to ignore. So clients are taking action much quicker than they otherwise do. So there are a few basic estate planning documents. It's what I call phase one of planning. The first set of documents is a will and a revocable trust. So a will basically governs the disposition of your assets at death. When you have a will and you have assets in your own name, you're stuck in the probate process, which for anybody who's lived through that is an onerous process. It's expensive because you're typically paying an attorney like me hourly rates to do it. And it just takes a very long time. So in a time when we're facing a pandemic and unfortunately very increased death rate, probate's going to be even more of a nightmare. So the way to get around that is to have a revocable trust. And it doesn't change the income or estate tax consequences of anything, but it does get you out of probate. So I see having a will, and it's typically called a pour over will, which states that any assets that are in your name will pour through this revocable trust. But by having those two documents, you can instruct how you want your assets to be distributed on death. You designate an executor and a trustee who is responsible for marshaling your assets, preserving your estate, paying creditors, debts, administration expenses, taxes, and then disposing of your assets. It appoints guardians for minor children, and it establishes trusts for when it's appropriate for asset protection and estate tax planning purposes. And again, when you have the will in conjunction with the revocable trust, it gets you out of probate. The second document is a healthcare proxy, where you name an agent to make medical decisions in the event that you're unable to do so yourself. Obviously, critically important right now.
Yeah.
The next is a power of attorney, where you name an agent to deal with your finances. There's a springing power of attorney where basically you name an agent and they can't act until you're incompetent or incapacitated. Or there's a durable power of attorney where you can name someone to act for you right now if needed. And so those are the primary documents, and in conjunction with a living will, which I would say is the last, not necessarily completely necessary, but to the extent that it makes sense, it's good to have. And that's basically where you express your wishes with respect to your healthcare. So if you're, God forbid, in a terminal state, you don't have long to live, or you're in a vegetative state, you decide whether or not you want artificial means to help support your life.
Great. No, that's helpful to start off with. So let's say we have these things in place and we know oh, we're sitting there, we needed to update, I haven't updated my will in 10 years, but I can't go to my attorney's office, I'm not gonna be able to sign things. What has
Mhm.
been put in place? Like, has the government thought about this? Has the, how would we actually go about doing that in this day and age when we can't even leave our homes?
Yeah, so that's been probably the most common question that I've been asked over the last few months. Is it possible to sign my documents during quarantine? Right. So right now we have social distancing requirements in New York and throughout the country. And many of these estate planning documents that I just mentioned, will, revocable trust, healthcare proxy, power of attorney, living will, they all require either that you sign in front of two witnesses and or notary public, and that's all established by different state statutes. Thankfully, the governors of most states at this point have stepped in. They've released executive orders basically saying that you can either remotely notarize or remotely witness these documents. So that's what we've been doing. To be honest, it makes me a bit nervous to do that because the statutes in these states say to do one thing, orders say you can do another, and we're not quite sure how that's going to play out. We've never been in that situation. So to me, it's much better for clients to have documents in place in case, God forbid, something happens. But my strong suggestion is once it's safe to do so, re-sign your documents the way they're, quote, supposed to be done according to state statute. Sign it in front of a notary and two witnesses, and make sure that it's done properly. There's another thing called a handwritten or a holographic will. That's valid in New York and a number of other states. They're entirely written in the testator's handwriting and signed. So I actually have in the past in certain situations have had to do this, namely like in a hospital situation where we couldn't get witnesses and notaries and didn't really have that much time. It comes into play now where we can't get witnesses, we can't get notaries in some states, or clients aren't savvy enough technologically speaking to get that done. So what can be done is you basically have a holographic will that pours your assets into the revocable trust. A revocable trust can be written out by an attorney, typed out. The holographic will have to be written, but the assets in the will pour into the revocable trust, which often in a lot of states, you can get away with signing that without having witnesses or a notary present. So sort of another potential option. The other thing that I would warn is that if someone owns property in multiple jurisdictions, you want to make sure that maybe it's valid to sign via remote notary or witness in New York, but if you have property in another state where that is not allowed, it could be a potential problem. So just seek appropriate counsel.
Okay. God, what a world we're living in.
Crazy.
And just to remind everyone, the Q&A is on the bottom of your screen. If you want to ask a question, please feel free, and I will read it out loud. Okay, just, what's on top of all of our minds? Our health. First and foremost, I go to Whole Foods on Saturday. It's all I think about, with the
Yep.
mask and such. And living here in New York, it's definitely our top of mind. So we're thinking about the necessity for healthcare directives, power of attorneys, HIPAA waivers. What do you think about today? We're seeing all these horrific instances where people get sick and they're in the hospital very quickly. So
Yes.
what should we be thinking about with these?
So with a HIPAA authorization, I say absolutely so necessary to put into place. I see so many people who sign healthcare proxies and don't sign a HIPAA waiver.
Can you explain what the HIPAA waiver is?
Sure. So under federal law, no one can access your medical records without having been authorized through what's called a HIPAA waiver. And it basically allows someone to take a look at your medical records. So a lot of times in a doctor's office, they'll ask you to fill out that form, especially for someone who has kids maybe who are teenagers but considered adults legally, so 19, 20-year-olds. And a lot of times they'll have the parents sign a HIPAA waiver. But it's important, especially in these times, because potentially you need somebody to act as agent under your healthcare proxy. And if they're unable to access your medical records, how are they going to possibly make a good informed decision with respect to your healthcare? So critically important right now. With respect to the healthcare directives and power of attorney that I mentioned as necessary documents, there are unique situations that we're confronting right now with coronavirus. So a lot of these living wills and do not resuscitate orders and healthcare proxies that people have signed, whether they obtained them online or in a hospital or elsewhere, may contain language that could completely be contrary to what you may wish to have done from a treatment standpoint during the pandemic. For instance, some of these documents prohibit intubation under all circumstances. And when people signed them years ago or before the pandemic, they were picturing an extended stay in a hospital connected to a bunch of tubes being kept alive artificially. And they said, no, thank you. But these days, if you're not terminally ill and you contract coronavirus, because it's a lower respiratory tract infection with symptoms felt in the chest and lungs, it's very possible that you would need to be intubated just to survive it. So I would say just revisit those living wills, do not resuscitate orders, healthcare proxies, and make sure that it does allow for intubation under these circumstances. It could be very well that you're intubated and you live, God be willing, for years and years after. So very important. With respect to the power of attorney, as I just mentioned, when someone has acute COVID symptoms, they're often put on a ventilator. And so when you're put on a ventilator, that requires you being induced in a state of a coma. And so you're incapacitated, even though you're receiving treatment and you otherwise are mentally capable, but you can't make financial decisions, obviously. So the power of attorney becomes important again, so that someone can handle your finances while you're incapacitated. So paying bills, writing checks, preparing your tax returns, etc.
Mm-hmm. Yeah, very important. Okay, we have a question. So for parents with young adult children, can they print off HIPAA waivers and medical power of attorneys online and have their kids sign them? So for like kids 18 and up?
So important, really valid point. When a child is over age 18, a parent loses all legal ability to make medical and healthcare decisions for them. A lot of people don't realize that. So if you have a 19-year-old who's in the hospital, you cannot access medical records, you can't make healthcare decisions, you can't even speak to their doctor. So very, very important that you have healthcare proxies, HIPAA authorizations, and power of attorneys in place for those who are 18 and over. I'm not the biggest fan of things that are obtained online because you don't have an attorney preparing it. It's not, particular to your situation and circumstances. But if that's not possible to see somebody who's a qualified attorney, then I would say that's a second best option, to have something rather than nothing.
Okay. And I also had someone ask almost on the opposite side. So for those adult children, what can they be doing to get their parents to be planning at this time? I mean, I don't know about you, but it was the hardest part of all this was getting my mom to not go to work before they put the shelter in place.
Yep.
My mom was taking pictures in her office, like, I'm the only person here. Like, there's a reason why. But
Yep.
What can adult children be asking or telling their parents in order to make sure that they're set?
Yeah. So with elderly parents, I'm a huge fan of the revocable trust that I mentioned. First of all, it gets you out of probate. So as a child, you're not stuck holding the bag, sitting as executor, having to deal with the probate process. So help yourself and get your parents out of probate. The other good thing about the revocable trust is if your parent becomes incompetent or incapacitated, then you're able to step in, or whomever they designate as a successor trustee, and take over all of their assets, pay their bills, all of that. If you don't have that in place, it's very possible you could have to go through a guardianship proceeding in court in order to be able to obtain access to their bank accounts and pay their bills and take care of their taxes and make sure their investments are in line, et cetera. So that would be the first thing. And then again, just make sure that those core documents are in place, right? The healthcare proxy, the power of attorney, the living will. Go over with them who they would want to name to make medical decisions for them. Find out what their wishes are with respect to medical care. Do they want to be kept alive artificially with artificial nutrition, hydration, respiration, if they're in a terminal condition or a vegetative state? Do they want to be resuscitated? So all of those questions that apply to everyone else applies even more to them.
So thinking about that, how do you recommend that we make sure that we have those, those documents in order so that if, our elderly parent dies and they live in a different state far away, that we know all those documents? Again, I know for myself, every time I go back to Chicago, my mom says she's going to sit down and go over everything, but has it ever happened? No.
And it won't.
Yeah.
So I always tell my clients, like, let your agents know under the healthcare proxy, the power of attorney, that they're named. Let them be prepared. Let them know where they keep documents. A lot of times, trust and estates attorneys maintain the original documents, so it makes it difficult for children and heirs to be able to find them. So I think it's important that you just even tell your mom, I need to know where the documents are at the very least.
Yeah.
Because otherwise, people, it could be too late before documents are found. So I think it's important. Also, make sure that your clients and your parents never keep documents in the bank. In a safe deposit box, because if something happens to them and they're gone, you have to go through a court process just to open it. So obviously, again, it's too late, and it takes a very long time, especially in these days when courts are closed and overwhelmed.
Mm-hmm. Okay, we have a bunch of questions. So, is it a good idea to put your name on your parents' bank accounts?
So I'm assuming that means as a joint tenant.
I think that means as a joint tenant. Yeah.
Right. So there are different types of ways of doing that. One is to have what's called a joint tenancy, what Emily and I are talking about, where you both have access to the assets. Typically that flows with a right of survivorship, where the asset automatically passes by operation of law to the survivor. I don't love that method. I prefer a convenience account where you give, especially for an elderly person, you give somebody signing authority on your account, but it's not ultimately passing to that person. Because I've seen too many situations where someone will name a daughter because that person's good at paying bills and willing to take over responsibility, but then it passes automatically to that daughter and potentially disinherits the other siblings. So you could run into trouble by doing that. You do want assets to pass through a will or a revocable trust for the most part, and not automatically because of the issues that can arise.
Okay. Yeah, to that point, we had someone, how effective are transfer on deaths in lieu of revocable trusts? What are the disadvantages of a transfer on death setup? So I think
so those transfer on death, it's called TOD or POD, payable on death.
And those are like on your account.
Exactly. Those are designations on account. I mean, that works okay for somebody who has very simple estate. Maybe they just have a few bank accounts. They have no tax issues, estate tax issues, and it passes and they don't have to deal with probate. But with the majority of people, it's not that simple. And with people of wealth, it's certainly not that simple. You want assets to pass into the appropriate vehicles, typically trusts, where you're giving asset protection to whomever you're leaving these assets to. When it's POD or TOD, it's not passing through trust. There is no asset protection. There is no tax planning inherent in that. There can't be. So I would say for the most simplest, that's fine. It's a good Band-Aid, but anything more than that, I, again, think it needs to pass through the documents.
Okay, makes sense. And then we have someone asking, at what level does it make sense for someone to have a revocable trust? Is there a threshold? I think it depends.
Totally depends. So again, with significant assets, always should have a revocable trust or a will in place so that you actually have the tax planning piece of it. I can't give you a number on, when it makes sense to have a revocable trust. I think honestly, it always makes sense to have a revocable trust because probate is such a hassle. And a revocable trust is almost always cheaper than probate. So if it comes down to, that, I would say get out of probate, simplify the life of whoever's inheriting your assets. So for me, it always makes sense unless, the fees for it are so onerous that someone just doesn't want to face that during their life.
Mm-hmm. Okay. And then this is for those of us with the control freak tendencies, this is me too. Can you please provide advice as to how to get comfortable with signing a power of attorney for financial decisions? That might be a larger question.
Well, it's funny because most of my control freak clients say, I'm only going to do a springing power of attorney because I don't want my agent to have the ability to make any decisions while I'm competent. But I actually think the reverse. To me, if you're not going to give your agent the ability to make financial decisions while you're competent and able to see what they're doing, how could you possibly trust them to
Yeah.
only make decisions when you're not with it and you have no idea what they're doing? But it's a leap of faith. You have to really trust the person. They have a tremendous amount of control over your finances. They can essentially do almost everything that you could do
Hmm.
under a power of attorney. So you just have to be comfortable with the person you name. Know that if you don't name anybody and it does come to the point where you become incompetent or incapacitated, there could be somebody who's going to go for a guardianship proceeding over you because they have to, in order to maintain your lifestyle and pay your bills, and it's not coming out of their pocket. So it's better that you make the choice instead of a court.
Okay. So, thinking about that assets have gone down, interest rates have gone down, what
Mhm.
can we be doing to be strategic during this time with depressed asset prices and low interest rates?
Yep. So for individuals of significant wealth, once your primary estate planning documents, those 4 or 5 primary things that we went over in the beginning, are in place,
Yeah.
you're ready for what I call phase 2 of estate planning. And so you can take advantage of the downturn in the market as an opportunity to leverage your lifetime federal estate tax exemption. I'll explain what that means in a
Yeah.
moment. But because the stock market has suppressed the value of assets, honestly, across most asset classes, making gifts at this time offers a lower tax cost, where you're able to get a lot more assets out because their value is reduced, to use the same amount of your estate tax exemption. You're also increasing the likelihood of appreciation of the gifted assets in the hands of your donee, as opposed to in your hands and in your taxable estate. So let's just talk about the types of gifts that you can make, and how we can take advantage of the market volatility. So you can either choose to make a gift using all or a portion of your lifetime exemption, or you can use the annual exclusion. In 2020, the lifetime federal estate tax exemption is $11.58 million. That's $11.58 million that each person who's a US person can transfer during their life or at their death, totally free of gift or estate tax. When you're above that, let's call it $11.5 million exemption, you are then facing a 40% gift or estate tax on
Mhm.
assets. The goal in estate tax planning is to use that $11.5 million, get it out of your estate, and pay as little tax as possible. This exemption of 11.5 is by far the highest we've ever had.
Mhm.
It's scheduled to sunset at the end of 2025 and return to what it was before Trump's legislation, and that's 5 million. Next year, if we have a Democrat in office, they're looking to pass a $3.5 million exemption. For me, the biggest concern is we just had the recent passage of the CARES Act with more stimulus bills to come.
Right.
So Congress is going to be looking for ways to, reduce these deficits, and I'm sure estate taxes is going to be at the top of the list.
Yeah.
Um, so that's number one, is to use the exemption. Number two is the annual exclusion that I mentioned, and that's $15,000 that you could give to as many individuals as you choose each year without using up your exemption and without filing a gift tax return. So with all of this turmoil in the world, obviously there's a lot of uncertainty, but these depressed asset values, low interest rates have all really created unique opportunities for estate planning. I'll mention a few of them that I happen to like, that I'm using for my clients at the moment. It's going to get a little sophisticated, so sorry. Stop me at any point in time, and obviously everyone, please feel free to ask questions. But the first is called a grantor retained annuity trust. It's a GRAT. It's a technique whereby assets are transferred to the trust, and the grantor contributing the assets retains the right to receive an annuity each year for a certain term of years. The amount of the gift is based on what the IRS calculates to be what the beneficiary is ultimately going to receive at the end of the term. So let's take an example. This is called a zeroed out GRAT. It's one of my favorite techniques. The donor transfers $10 million in my example to a GRAT with a term of 10 years and receives the right to receive $1 million back every single year for the 10-year period. Based on the mathematics of this approach, the IRS figures there's going to be little or nothing left over for the beneficiary because you've gifted 10 million and you've taken 10 million back. The benefit occurs when the assets appreciate at a higher rate than what the IRS calls a hurdle rate. Crazy enough, that rate is 0.8% for May. It's like the lowest that I ever remember seeing in my 20 plus years of practice. And so to the extent that the assets appreciate at a rate higher than that 0.8% hurdle rate, you've transferred the value to the beneficiaries at zero cost. You haven't used any of your exemption. So that's one thing that we're doing a lot of. Another is to a grantor trust. A grantor trust is a trust that it's called intentionally defective. It's purposefully structured so that it's income taxable to the grantor. And so you can use a portion of your exemption or all of your exemption, gift it to a grantor trust for the benefit of kids or other loved ones. You've now gotten that asset out of your estate, now at suppressed values, using all or a portion of your exemption, and any income or appreciation on that asset is totally out of your estate. Instead of making a gift to that grantor trust, you could structure it as a sale, where basically a family sells an asset to a trust, and you use the income from the trust to repay the loan, or at least the interest on the loan. And again, it's structured as a grantor trust. There's no recognition of income taxes upon the sale. But if the asset being sold is low at the present time, and you're comfortable that the income generated from the asset will satisfy the installment obligation, then you've transferred all of that appreciation to your heirs. So those are, I would say, three examples of, the sophisticated techniques that we're using to take advantage of the low interest rates, the low asset values, and get these assets out of your estate while we have a high exemption.
Yeah. Okay, and so thinking about, hold on, we have a couple questions. What happens for any amount above the exemption that you put into a trust? Is that taxed at 40%?
It is. It's 40% on the federal level. And remember, we have estate taxes in some states. Like for New York, we have roughly a $5.5 million exemption, but it's actually a cliff tax. So if you are, and this is a state tax, not gift tax, but if you die with assets at around 6.1 million, you actually fall off the cliff and you're taxed at $1. That's on top of federal. Every state has different taxes. Some have no taxes. Most do not have gift taxes. So to the extent that you gift an asset during your life, and let's say you're a New York resident, you've actually now gotten yourself out of New York tax with respect to that gift completely. But basically, to answer that question, you do have to pay taxes on any gifts above the exemption amount. It's if you're in a state, which is most states other than Connecticut, if you're in a state that doesn't have a gift tax, you're not paying state gift or estate tax, but you are paying federal at 40%. The interesting thing to note is it's better to pay gift tax than estate tax. So if you make a gift of $1 million above your exemption, you are now paying an additional 40% on top of the million. You're not paying tax on the asset. It's tax exclusive. Whereas when you pass away, you're paying estate tax on the assets that you're paying tax on, if you could follow what I'm saying. So it's almost double dipping when you die, because you're using those taxes to pay tax that's taxed. So it's always better to make a taxable gift than it is to die within your estate and pay the tax.
Okay. And then we had a question about, should we think about intra-family loans right now?
Yeah, so intra-family loans, again, we have interest rates at historical lows. Loans among family members is what intra-family loans are. It's a really popular means now of assisting family members. It can be a way of transferring family business interests, in the way that I talked about, intentionally defective grantor trust and having a sale, or it could be just a way of parents supporting their children when they want to finance major purchases like a home. So a properly structured and managed intra-family loan has many benefits. Lower interest rates for the borrower as opposed to commercial lending rates. There's no credit checks or reporting, obviously. There's no loan costs. And frankly, it's a better return rate for the lender than the cash sitting in a bank account that makes nothing. So it's sort of a win-win in this environment for everyone. The one thing that has to be remembered is that these loans are really scrutinized by the IRS. They want to make sure that family members aren't making a loan, which is really a disguised gift.
Right.
So they have to be carefully structured and administered so that it's a real obligation. It's a real arm's length transaction instead of something really that's a disguised gift.
So definitely talk to your attorney before you do anything
Absolutely,
like that.
absolutely.
Don't just go wiring money after this.
Yes. Yep.
So you touched on this, but we're thinking about so the exemption amounts that may phase out in 5
Yes.
years. Should we
Yep.
be thinking about that right now?
100%. So the IRS released legislation a few months ago, basically saying that to the extent that you use your 11 and a half or anything short of that, and we go down to the 3.5 or even the 1 that some of the Democrats are talking about, that if you've used anything above a $1 million exemption or 3.5 that may come in the future, you've grandfathered in that use. So it's so important for the wealthy whose cash flow and future needs will allow for that gift, to make that gift. The other good thing is, again, we have really low asset values. So now is the time when we could do that to get more out of your estate. It's basically leveraging the use of your exemption. We typically leverage the exemption with assets that are subject to valuation discounts. So like commercial real estate, closely held businesses, things like that. You can usually take a discount on those assets for lack of marketability and minority interests, and you could get more out of your estate because it's typically a haircut on the asset value of like 30 to 40%. I see our current suppressed asset values as basically being an additional discount. So now between this lower tax cost of gifting and our increased exemption that you could pretty much bet is going to go down, now is the ideal time to make gifts.
So yeah, our next question was actually about gifting business interests during this time. So it sounds like if you're a business owner, you should talk to your attorney about thinking about that right now.
100%. I mean, the other thing is it depends. A lot of people come to me, I just sold my business for $50 million. What can I do?
Yeah.
It's too late. You missed the boat. I mean, really with business interests, if you're planning an exit at any point in time, the best time to do your planning is while you could get those lower valuations, before there's a letter of intent signed, before there's, that higher value on your business. So obviously the sooner the better. And especially when assets are so suppressed right now, now is an ideal time to get these assets out of your estate.
Okay. And we had another question about charitable lead annuity trust during this time. First, can you explain what that is so that everyone understands, and then thoughts on it?
Sure. So it's called a CLAT, if you've heard of a CLAT, a charitable lead annuity trust. Under this technique, assets are transferred to a trust, and a charity receives the income from the assets based on an IRS interest rate for a certain term of years. So that rate that I had mentioned, the 0.8%, it's actually the rate that's used for a CLAT as well. On the expiration of the trust term, the assets are distributed to the beneficiaries. As with a GRAT that we talked about, the grantor retained annuity trust, if the assets appreciate at or above that 0.8% for May IRS interest rate, then the ultimate beneficiaries can receive value at a very reduced transfer tax cost. So great thing to do right now with low interest rates.
Okay, great. And so it sounds like for our charitable clients too, we can start to think about some things. So
Absolutely.
if you have any other questions, please write them in now. So it sounds like, this is a great time to start thinking about this and such.
Mhm.
Anything else that we didn't touch on that you think that people should be thinking about right now?
Yeah, one thing I would mention is typically when you're using the exemption, and certainly historically, this is what has been done. You make a gift, you use a portion of your exemption, you file a gift tax return, and frankly, you give up that asset. You give up ownership and control of that asset. And in these really uncertain times, and especially because none of us can predict the future, it's scary to part with those assets. And so before you give these assets to a child or a trust for the benefit of children, you never see the assets again. Clients who have done this over time, I've often seen remorse, where they said, oh crap, I gifted way too much. I would have liked to buy another vacation home, or times are tough. I wish I hadn't gifted that $5 million. And so what I love to do for my clients who are married is what's called a spousal lifetime access trust, or a SLAT, where basically you transfer assets, you gift them to a trust. This could be business interests for business owners. It could be marketable securities. It could be essentially any asset. And you gift it to a trust for the benefit of kids and your spouse. You use your exemption, any income and appreciation on that asset is totally out of your taxable estate. But the beauty of using the SLAT is if at any point in time you had a reversal, of finances or a need that you didn't predict and you want that money back, you could distribute the assets out to your spouse, who's a beneficiary of that trust, and sort of have backdoor access to it. So a good thing for people who are hesitant about gifting because they just don't know what the future brings, it's a good option because it provides flexibility to actually get those assets back in the future.
Great. So it sounds like people should sit down in the time that they take, look over their documents. If they have a spouse, look over their documents with them, and also call their family members to start thinking about this and get this in place. And
Absolutely.
I know you've seen people kind of drag this out for a long time, and so I think the urgency is here,
Yeah.
right? Yeah.
Yeah. Yeah. Sadly, it's here. As I said, we're, for the first time in my life, and probably everyone on this call, we're facing an imminent threat. Estate planning used to be something that could be put on the back burner, that people could procrastinate because it wasn't real. It's real.
Yeah. Yeah. Very scary times.
Yeah.
Okay. Well, we got a lot of thank yous. If we didn't answer your question, your LOS contact will reach out to you. We'll work with Laura to make sure that all of your questions are answered.
Yep.
So please go talk to your trust and estates attorney, and at LOS, we're here as a resource. Again, we do not provide trust and estates planning advice, but we can help you find people like Laura. Thank you for the time, everyone. Stay safe.
Thank you.
Thank you, Laura. I know you're at home with your kids, and getting a quiet place cannot be easy. So we really appreciate it.
Thank
And
you so much. Thank you for having me. I really appreciate it.
of course, thank you.
Well, bye-bye, everybody.
Bye.